So welcome everybody to the 16th webinar in the series organized by the Knowledge Network for Innovation and Access to Medicines. I'm really delighted today that we're going to be addressing the question of extended monopolies and what the impact is that they have on innovation and access to medicines, with two really terrific speakers whom I will introduce to you in a bit more detail in just a minute. But we're very delighted to welcome today Professor Julia Paranhos from the University of Rio de Janeiro and Dr. Elena Thun, Director of Medicines, Law and Policy. Just a few words about how the webinar will run and about the project in general before we dive into today's topic. So first, the goal of the Knowledge Network is to maximize the contributions of research and analysis, such as the studies being presented today, to achieving globally equitable innovation and access to medicines. We started the webinar series in order to try to facilitate two-way flows of knowledge between the research and policy and practice communities. So we do hope that many of you will share your reflections and your questions and your knowledge throughout the webinar through the chat function. We have a website for the project called the Knowledge Portal, and the Knowledge Portal seeks to serve as a one-stop source, providing information, research, and analysis on a whole range of policies relating to both innovation and access, organized along three themes: pricing, intellectual property, and innovation. And by the way, we have a new page where we're trying to gather a number of data sources relating to coronavirus, COVID-19 technologies. In addition to research syntheses, data sources, and a list of research gaps, you can find on this website also recordings of all of our previous webinars and today's webinar as well. It should be posted within a couple of days. If you have a comment or a question, please type it into chat. Be sure that you select to all panelists and attendees so that everybody can see your question. You can also raise your hand if you'd like to pose your question directly orally, and this really depends on the amount of time we have. After the webinar finishes, we have a very, very quick survey that we'd like everybody to fill out, and that includes the possibility of suggesting topics for future webinars. Please send any suggestions you might have beyond the survey to the email address that you see above the screen. So without further ado, let me dive into the topic for today: extending monopolies, evidence from Brazil and Europe on the impact on both innovation and access to medicines. As many of you are already very aware, exclusive rights such as patents, data exclusivity, other kinds of rights are intended to promote pharmaceutical innovation, and the way that they do this is by granting time-limited monopolies. The extension of these monopoly rights, whether by making those rights longer, broader, or stronger, is intended to add an additional incentive for innovation, particularly in areas where there isn't yet perceived to be enough of an incentive. So orphan diseases or rare diseases is one area where we've seen this used a lot, as well as, of course, pediatric medicines, etc. One clear result of an extended monopoly is, of course, that medicines prices can be much higher than they would be than if we had generic competition. And so there are two key questions that come up regarding extended monopolies. The first is, what is in fact the impact on the affordability and access to medicines that results from extending monopolies? And the second is, do these extended monopolies in fact generate the innovation that they were meant to incentivize? Do they address the unmet health needs that were the intended societal purpose of the policy in the first place? With us today, we have two world-class, well-known, very well-established experts who will be sharing their research on these two questions. First, we'll be hearing from Professor Julia Paranhos. She's an associate professor at the Economics Institute, as I mentioned earlier, at the University of Rio de Janeiro, as well as the coordinator of the Economics of Innovation Research Group. You can find, by the way, full-length biographies of our speakers on our website, so I'll just say a few words briefly about each of our speakers. Dr. Paranhos has a doctorate in the economics of industry and technology. She is an expert on innovation and has a particular interest in the intersection of industry and academia and university research. So she'll be presenting for about the first 15 minutes. minutes. Second, we'll have Dr. Elena Toon, who's the Director of Medicine's Law and Policy. She has an extensive experience working on pharmaceutical policies, in particular intellectual property rights. She is also the founding executive director of the Medicine's Patent Pool, has recently been recognized by the King of the Netherlands for her major contributions to the public interest in her work in this area. So after each of our speakers presents, we'll open the floor for Q&A. I'm hoping we'll have at least the last 20 minutes or so, 25 minutes to engage in back and forth with all of you. Before I close, I should say that I do believe we have some of the co-authors of both of the papers that are being presented today present, and that if some of the questions come up that they have a particular expertise in responding to them, then hopefully they will also be able to dive in. So I'll mention them when we get to the Q&A section. So thank you very much. Without further ado, let me give the floor over to you, Dr. Paranhos.
Oops. Hello. Can you see my slides?
I see you and we hear you very well. I don't yet see your slides.
Oh yeah, I'm not sharing, just a minute. Yes, now?
Yes, perfect.
Okay, perfect. Yes, well, thank you very much. It's a pleasure to be here today. I'm gonna present our paper on public health system increasing costs due to the extension of drug patent terms. So the context here, let me see, how do I, yes. Well, the context here is that Brazil's patent law has adopted provisions that go beyond the international standards, which are actually TRIPS+. The sole paragraph of Article 40 of the intellectual property law expands the protection of intellectual property rights by ensuring that patents are valid for more than 10 years from the date of the grant. It was thought to be an exception, not the rule. However, the Brazilian Patent Office, INPE, has a high backlog of patent applications pending a final decision, and a low infrastructure, which causes the extension of the vast majority of pharmaceutical patents due to the delays in the examination. It takes, on average, 13 years in the pharmaceutical area. Mercadante, my co-author, in his master dissertation, showed that 92.2% of granted pharma patents in Brazil from 1997 to 2018 will have more than 20 years. It is 630 patents. It happens mostly because of what he called the temporal dimension of the backlog, because pending applications idle for 7 years while they wait for the first technical statement. The technical examination takes on average 3.5 years. So given the strong provisional rights related to the pharmaceutical patent applications, this will delay the entrance of competitors in the market. So it raises the question, what is the potential additional cost to the Brazilian Unified Health System, SUS, caused by the extension of patent term conferred by the sole paragraph of Article 40 of the Intellectual Property Law? To answer this question, we did a selection of drugs from the federal government public procurement website. We looked for the high cost drugs and then their patent situation. Then we selected 9 drugs divided in these 3 groups. The first one, Group A, are granted patents that will be valid for more than 20 years. Group B are pending applications that, if granted, will be valid for more than 20 years because they were filed more than 10 years ago. And Group C are mailbox patents, the ones that were filed during TRIPS transitional period that in Brazil went till May 1997. So they are already granted and they will be valid for more than 20 years if the sole paragraph of Article 229 of the Intellectual Property Law is reformed. So the 9 drugs were those here, group A, B, and C. We identified their patents and we calculate the years of extension, counting the extra years from the 20 years after the filing date. That would be the 20 years from TRIPS, and that our law will give it the extra years for the extension. So each patent has its own extension period, okay? For group B that were pending applications, we considered the data of February, 18th February 2019, that was the date of our analysis. Then we looked at the public procurement data from 2014 and 2018 to calculate the annual average value, the annual average quantity to each drug, and to look at the total expenditure of the Ministry of Health during this period that was of 10 billion reais, and the annual average expenditure that was 1 billion, almost 2 billion reais, okay? I left the value in dollars with the exchange rate from the data of our analysis here on parentheses. And this annual expenditure, it represents 1.5 of SUS budget in 2018 with only these 9 drugs, okay? So considering that the same characteristics of purchase from 2014 and 2018 would continue during the periods of patent extensions, the Ministry of Health would spend 6.8 billion reais on the purchases. So to identify the impact to the public health system, we looked for more economical alternatives, either actual or hypothetical ones. The actual price reduction were based on generic prices found in the international market. We had the collaboration of a pharmacist to look for these prices. The references where we found the prices are at the end of the presentation. And we found the prices for these generics with these reductions. These would allow a saving with these 4 drugs that are already available in the market, the generic versions. A saving of 1.2 billion reais, and which represents a reduction of 75.5% on the Ministry of Health spending. We also had some hypothetical alternatives with price reductions based on market standards. So we did 3 hypothetical alternatives. The basic one, we consider a reduction on biosimilar prices of 10% and on generic prices of 40%. And it would represent a saving of 1.2 billion reais for the Ministry of Health with the 9 drugs. Now I'm considering the 9 drugs, okay? For the average alternative, we considered a reduction in the price of biosimilars of 30% and on the price of generics of 60%. And it would allow the Ministry of Health to save 2.6 billion reais. In the third alternative, the drastic one, generic prices would reduce 80% and biosimilars would reduce 50%, and the savings would be of 3.9 billion reais. It would represent 57.4% less than the amount that the Ministry of Health should have. if there were no reductions and if they still buy the versions, the reference versions, the branded versions. So it actually represents, it equals the annual expenditure of 2 years with these 9 drugs. So it's a very significant reduction. And all these reductions were found, the references are also at the end of the presentation, and there were reductions found in the literature or international market. So it will actually be possible to have these reductions. What is important to highlight here also is the impact of the mailbox patents. In this drastic reduction, the group C would represent 53% of the expenditure, the saving, the available saving, which is 2 billion reais. So even though the sole paragraph of Article 229 is not reformed, a judicial process is guaranteeing the extension of patent terms. So the legal uncertainty remains and is delaying the entrance of competitors in the market. So we have some complementary recommendations here that are threefold. To the Supreme Court to approve the direct plea of unconstitutionality number 5529 from 2016 and revoke the patent term extension clause conferred by the sole paragraph of Article 40 of the intellectual property law in Brazil. Or at least to make it clear that it excludes mailbox patents, which represent the largest spending group in the sample as showed before. The second recommendation is for the Ministry of Health to be more proactive in requesting the fast track of drug patents applications that may be extended. INPE, the Brazilian Patent Office, has a resolution that the Ministry of Health may ask for the fast track analysis of patents related to drugs that are important to public health system. And the Ministry of Health has hardly used it, only 16 times. The third recommendation is for INPE to have its financial autonomy, to constitute the required personnel to enhance the quality, efficiency, and independence of patent exams, and to render patent term extensions the exception, not the rule as it is today. In January 2019, there were 641 pending applications per examiner in INPE. It is 112 pending applications per examiner in the 5 largest patent offices. So INPE has a low infrastructure and personnel to respond to the size of the Brazilian market. So in conclusion, we analyze 9 drugs, but there are indications that there are about 60 drugs on the market today that will have patent exclusivity for more than 20 years due to the sole paragraph of Article 40. Includes some molecules that with potential responses to COVID-19. So it's urgent to find a solution to this situation of extended patent terms in Brazil. So these are the references for generic prices and hypothetical alternatives. More information will be available in the forthcoming paper that we are publishing. Here is the reference in the Brazilian journal. Here is my contact and the team that worked with me, Lia Hasenclever and Eduardo Mercadante, who are economists, and Thiago Azevedo, who is a pharmacist. There is a link at the end for the executive summary with the final version with these numbers in reais and dollars from 2019. So thank you very much. And it was a pleasure to be here today, and I'm available for questions. Thank you.
Thank you so much, Dr. Perenius, for that very clear and concise presentation. It's really quite striking to see what a huge budgetary impact a relatively, I would say, obscure legal provision can make, and of course the follow-on impacts on people's health is even more concerning. I think one of the things that we can observe is that the policy tool of extending monopolies is certainly not limited to any one country in the world. There are tools that have been implemented in many different regions, not least of which Europe. So let me turn now to our second speaker, Elena Thun, over to you.
Thank you, Suri. And first of all, thank you for inviting me to speak. I hope you can hear me.
Yes, I hear you well.
Great. Okay. And it is very nice to meet Julia on this webinar and to see also so many of my Brazilian friends already active in the chat box. I'm going to talk about the incentive mechanisms in the European Union. I will share my screen. I have a few slides. There we go. Okay, I hope you can see them. So I'll run you through the overview of the European pharmaceutical incentive mechanisms, which is quite a generous one. In fact, this slide is in a way a summary of my presentation. It depicts the various patent and regulatory based market exclusivities that exist in the European Union. Everything that is gray and blue and purple is patent system based, and everything that is red and pink are exclusive rights, exclusivities that are granted through the medicines regulatory system. I will not spend a lot of time on, hold on, how do I, okay, here we go. I will not spend a lot of time on patents, but really focus on the regulatory exclusivities. But just a few words about patents. Of course, the European Union member states are TRIPS compliant. They grant patents that last at least for 20 years. Important to note that patents are national. There is no EU patent, for example. There are patents that can be granted through the European Patent Office, through application at the European Patent Office, but the execution and the enforcement, but also measures to intervene, for example, if a country would want to issue a compulsory license, those are all matters of national competency, not EU competency. That is different for the regulatory framework. There are extensions possible beyond the 20 year. They're called supplementary protection certificate, and it's a bit of a hybrid. It is not just a patent extension, it is a patent years of additional patent-like protection. Once the 20-year patent has expired, the basic notion for the establishment of this is to compensate for the lack of commercial exploitation before the medicine's regulatory approval. And an important reason given for this additional exclusivity, which will ensure 15 years of effective patent protection, is to increase research and development in the European Union. It is deemed necessary to cover the investment put into the research. I've put the regulation numbers on the slide so you can look things up should you be interested. Here's an example of the consequences of this supplementary protection certificate. This relates to an HIV medicine that is an essential medicine for and used in the prevention of HIV infection. The SPC status, just like the patents, can vary per member state. The regulation may be European, but the execution of the SPCs are a matter of national law. Now, this SPC for Truvada, this is a combination of tenofovir and emtricitabine, a Gilead product, was never granted in the Netherlands. It was revoked in France, but it was still in force in Switzerland. And here you see the difference in price for a 1 month supply, which in the Netherlands had gone down to around 30 euros, in France 170, but in Switzerland, where Gilead retains its market monopoly, the price is 800 euro per month use. Another form of exclusivity, which comes through the regulatory system, is called data exclusivity. In the European Union, and this is Europe-wide, data exclusivity was first introduced in 1987. At first, it was 6 years for small molecules and 10 years for biologics. That was because the patentability for those biologics at the time was not entirely clear. In 2004, this EU regulation was amended and expanded to what became known as the 8+2+1 rule. That means 8 years of data exclusivity and then 2 years of market exclusivity. So the data exclusivity means that a generic manufacturer cannot, with reference to the clinical test data on file with the European Medicines Agency, apply for a marketing authorization. So this is a de facto market exclusivity. After the data exclusivity expires, there is a 2-year market exclusivity, during which period the generic company can apply for marketing authorization, but not market the product yet, and that can, under certain circumstances, be expanded with an extra year. So that's the 8+2+1 rule. Again, the rationale for this is to protect the investment in the production of test data needed to obtain marketing authorization by preventing use by generic companies for a certain period of time. During the period of data exclusivity, as I mentioned, a generic competitor product cannot be considered for registration. This data exclusivity is automatic. It does not require an application nor evidence of its need. It is assumed that it is needed, but it is not being verified. It is granted regardless of the level of investment in generating the test data. So companies do not have to prove that how much money they've actually spent on doing this. And it is quietly enforced through medicines regulation and through medicines regulatory agency whose primary job is actually the protection of the health and safety of consumers, not so much protection of market exclusivities. It's important to note that there's no international obligation to provide data exclusivity. The World Trade Organization's agreement on trade-related aspects of intellectual property rights, the TRIPS agreement, Article 39.3, talks about protection of certain kinds of data related to new chemical entities against unfair commercial use. But it does not create the obligation to provide new forms of intellectual property. Majority of the World Trade Organization members do not provide data exclusivity. The European Union generally requires data exclusivity commitments in its free trade agreements with other countries. There is an issue with data exclusivity, regardless of the question how essential and how necessary it is. An issue that is being discussed today, also particularly in the context of COVID-19, where we see European Union member states getting an increased appetite for exploring compulsory licensing, or at least be ready for compulsory licensing should it be necessary in the context of COVID-19. Data exclusivity can actually hamper the effective use of compulsory licensing by EU member states, because EU law does not have a waiver for data exclusivity to facilitate the use of compulsory licensing for domestic use by EU member states. You can imagine a country issuing a compulsory license to generic manufacturers, but if those generic manufacturers then cannot obtain a marketing authorization for these products, then the compulsory license remains moot. The EU regulation on compulsory licensing of patents for the manufacture of pharmaceutical products for exports outside the EU, this is based on the which is now Article 31 bis of the TRIPS agreement, does in fact include such a waiver that enables the European Medicines Agency to provide opinions. But such a waiver does not exist for the use of compulsory licensing within the European Union. It is something that, in our view, needs to be fixed urgently. This includes for urgent situations or the kind of situation that might occur in the context of COVID-19. No exceptions possible. A practical example of how data exclusivity can play out. This is the case of Ukraine. Ukraine is not a member of the European Union, but it has an agreement with the EU in which it was required to start providing 5-year data exclusivity. Sofosbuvir, an essential medicine for the treatment of hepatitis C, is not patented in the Ukraine. And a generic company, Farco, a company that's producing in Egypt, was the first to apply for a marketing authorization in the Ukraine, which was granted in 2015, the 18th of November. The originator company, Gilead, was granted a marketing authorization in October, claiming data exclusivity until 2020. And under legal pressure, including an investor-state dispute threat, the Ukraine revoked Farco's marketing authorization. Now, Gilead would not have been able to do that on the basis of data exclusivity had the Ukraine not been obliged to implement data exclusivity through the EU agreement. Another set of market exclusivities in the European Union comes through the incentive mechanism for the development of orphan medicines. These are medicines meant to treat rare diseases. And you see in this slide here that the yellow box, the market exclusivity or for orphan indications also comes through the regulatory mechanism. There are, it targets diseases that affect 5 or less patients per 10,000 of population in the European Union. It is estimated that there are at least 8,000 such rare diseases and that about 30 million EU citizens are affected. The regulation provides for push and pull incentives. There's protocol assistance at the European Medicines Agency, fee waiver, which makes it cheaper to register a drug for the treatment of a rare disease, and a framework for EU and member states R&D funding. But important in this context is it provides also a 10-year market exclusivity. You can apply for that when you want to register a drug to treat a rare disease. This market exclusivity again is a very strong one. I sometimes say patents in the European Union is perhaps less of our worry. These kinds of exclusivities that come through the regulatory system are very strong, and there are really no remedies against it. Or actually no effective remedies. Here's an example of what has happened in the Netherlands, my own country. A medicine, CDCA, it's a medicine that was used in the past. It's a very old compound. It was used in the past for the treatment of gallstones. For years it was off-label used for the treatment of a rare metabolic disease. The cost was around 300 euros per patient per year. A company obtained marketing rights for this product and withdrew it. It also bought up production capacity that existed. In 2004, this company obtained orphan drug designation based on the presentation of 2 small trials at the European Medicines Agency. And as a result, it became the sole supplier of this product, and it increased the price from 300 euros per patient per year to 158,000 per patient per year. This led to a huge outcry in the Netherlands, and hospital pharmacists have taken it upon themselves to start making the product themselves to be able to supply it, because the reimbursement system was no longer paying for this product at this price. But this shows the kinds of manipulations of the Orphan Drug Act that can happen with products, often old molecules that are known in medical practice, but the regulation allows for companies to take such knowledge and to take such products and turn them into monopolies. There is these issues have led to quite a bit of debate. A few years ago, in 2016, this is a typo, this should be 2016, the EU Council decided to review the pharmaceutical incentive system to strengthen the balance in the pharmaceutical system in the EU and its member states. This review is ongoing, but it is going very, very slowly, and we've recently learned that the review is being narrowed down to only focus on the Orphan Drug Act and on the pediatric incentives. While of course it's also very important to look at the supplementary protection certificates, because they add a significant amount of exclusive of monopoly to the products. The European Commission has commissioned studies from a variety of actors, the Max Planck Institute, the Copenhagen Economics and Technopolis. Not all reports are published yet by the Commission. The reports on the supplementary protection certificates, which have been done by Max Planck and Copenhagen Economics, is looked at that as well. The Technopolis report that covered a variety of incentive mechanisms have been published, but there's also a report on the Orphan Drug Act that we know is finished and has been submitted to the Commission, but has not been released. And the narrowing of this review is really a reason of concern. Particularly since the preliminary findings of these reports point out that first of all, the EU system is a very generous system. In that sense, it certainly meets the requirements of offering generous incentives to the pharmaceutical industry, but it questions whether it actually meets the stated objectives, such as stimulating European industry and attract industry, which since these incentives are available for both European industries and any other industry on the planet, all companies can benefit from them. One of the objectives of the SPC was that it would achieve lower prices by offering longer periods to recoup the investment. And that, of course, has not materialized. I think that was a rather naive objective, because the very opposite happens when you grant a monopoly. The prices remain high or increase. But key is, of course, the question: have these mechanisms actually stimulated the research and development that is expected? With regard to the SPC regulation, the Technopolis report stated that it offers companies an adequate compensation for their effective loss of patent term. However, as an incentivizing mechanism, the report says the effect is much less clear. So there is quite a bit of work to be done there. When I looked into the history of these various mechanisms, it struck me that that there's a lot of assumptions behind them. There is a famous quote from a European Commission official who says, monopolies are good, more monopolies are better. So the longer these exclusive rights can last, the better. And that has been a bit the basis of this. So the high medicines pricing issue and the questions that these exclusive rights raise of course, is now a global issue. I think this is for the European Union still very much the beginning of a debate, but it's becoming increasingly urgent. So with that, I thank you for your attention. We've done briefing papers on these various incentives mechanisms that you can download on our website, and here you will find the direct link to that. Thank you very much.
Thank you so much, Ellen, again, for a very clear and concise presentation on an extremely complex topic. I think that graphic that you first put up showing how multiple monopolies stack and extend over time is really one of the most striking and clearest illustrations I've seen of the system. It's a hard one to explain, especially to non-lawyers, but thank you for having done such a great job of doing so. Let me ask also, Dr. Paraños, if you would rejoin us on video. I'd like to turn now to Q&A. And as mentioned earlier, we do have a number of questions that have already come in. If you'd like to pose more, please feel free to do that in the chat function, selecting all panelists and attendees. And regarding some of the questions on Dr. Paraños' study, we do have Eduardo Mercadante and Professor Leah Hassenclaver, who have kindly also joined us during this webinar. One of the first questions that has come up actually is regarding Brazil. So I'm going to pose this first one to Dr. Paraños regarding what in fact is the average patent life, and I think implicit in that question, average patent life or effective patent life for drugs in Brazil. You showed some examples, but across medicines more broadly, what would you say is the average patent life? And are there, are some of these extensions necessary in your view?
Well, INPE has been taking 13 years in average to take the final decision of pharma patents. So in average, it's 23 years, the time of the pharmaceutical patents in Brazil. But we have not one, but some of them that are almost 30 years. The one in the study, there were more than 28 years. And it was the counting to the data we did, right? In 2019, because some other ones that would have 7 years of extension in 2019. If it was not, it does not have the final decision yet, it will have 8 today, right? So it's the ones that are still waiting for the final decision are increasing. So an average would be 23, but it can be much more. And no, I don't think there is, well, we didn't find so far anyone that would be good for the public health system and to the society in Brazil to have all this time. Actually, we're thinking here about the effects for we have a unified system, a public system, public health system. So the sustainability of this system is quite complex and difficult. So these extensions are actually increasing, and the costs of the unified system and affecting its sustainability, and also the impacts in the national pharmaceutical companies. The Brazilian market had increased a lot in the last 20 years, and the national pharmaceutical companies are actually investing more in innovative activities and increasing their technological accumulation. So it's actually blocking their innovations. So you have the effects on both sides here. So yeah, I think it's.
Thank you. I think, I mean, one thing that strikes me is when you talk about 23-year, 30-year patent terms, we see a very similar pattern in Brazil as in Europe, where you see this stacking or this gradual extension. And if we recall that prior to TRIPS, patents were either not granted at all on pharmaceuticals, or 7 years, 13 years, 17 years, and we're seeing really just this rubber band type extension. It's really quite remarkable. I wanted to turn, Ellen, to you, I think one of the key questions that comes up is how necessary are these extensions? And what kinds of data or information would we need in order to really make an assessment on that? I think the impact on price is very clear. We see that in the study in Brazil. Other studies have shown, of course, the impact on price. But the counterweight and the counter argument is always, well, we need this in order to actually get the innovation that is not otherwise going to exist. And I think the quote that you showed at the end is it's not certain, for example, what is the impact of SPCs on innovation, but what would we need to know to actually be able to answer these questions with more rigor and objectivity?
Well, thank you for that question. I think the European Commission publishing the orphan drug report that they commissioned will probably answer some of these questions. So that would be step number one, because we do need more sort of assessment of the evidence. These policies have been put in place are not evidence-based policies. I would say they're belief-based policies. There is a sort of, the patent system and the subsequent market exclusivity system is very much based on the assumption that that is what you need. Now, of course, if you give market monopolies, you give the opportunity for companies to charge high prices, to overcharge, and the assumption is that with that overcharging of the price, that investments are made. And I think that to a certain extent, that is probably true, but that doesn't mean it is the most efficient way of doing it. If you look at the orphan drugs, there were 8 treatments available when the Orphan Drug Act came into being in 20 years ago. In those 20 years, 196 orphan drugs have been approved by the Medicines Agency, so that you could say that is a success perhaps of that regulation. But you also have to acknowledge that between 5,000 to 7,000 rare diseases do still not have a treatment. Several of these 196 medicines have actually gone on to become blockbusters. A product like Gleevec, used for the treatment of leukemia, has an orphan drug indication, or had an orphan drug indication in the European Union, and that is a product that made billions for the company. So does such a product fall within the orphan framework? Now, what we do know is if you pay people to do certain things, they in general do that. So I would argue that having products developed for orphan diseases that are priority diseases, that are really serious diseases, people are left without treatments, I would say let's just fund that directly. Which in a way has happened with some of these products that unfortunately then got orphan indication and became monopolistic products, but fund that work directly. The European Medicines Agency has just announced that it will make it easier for academic researchers that are involved in this kind of work to seek support from the European Medicines Agency without having to pay the agency's fee, which could lead to academia actually registering these drugs and prevent the monopolization by corporations. But these are, of course, sort of intermediate measures. But I think what we need to look at is, aren't there a better way, more diverse way of actually financing this directly?
I think that definitely raises a key theme that has been raised by our audience as well regarding what kind of alternatives might there be. I want to come back to that in just a couple of minutes, but let me first turn back to Julia, because we've had a number of questions coming in about the situation in Brazil. And I think one trend perhaps we can see is that governments are really reviewing, both in Europe and in Brazil, perhaps elsewhere, are these incentives in fact doing what we want them to do for society? And there is this case of the Supreme Court in Brazil that you mentioned in your presentation. What's going on? Maybe you could give us just a quick additional update on what's going on with that case, and what is the likelihood that in Brazil will further monopoly extensions be implemented? I mean, in what direction do you see things? Moving?
Yes, the direct plea of unconstitutionality is from 2016, and actually there was one process before, and this one entered again by the interdisciplinary HIV Association and the National Pharmaceutical and Pharmacochemical Association of National Companies in 2016. And the process comes and no decision is made. And last month, it was supposed to have a hearing date, but then another company association of the big national pharmaceutical companies asked to become a friend of the court. And then it was accepted, and they're still waiting. Then the hearing was postponed, and we are waiting for another entrance of the date of the discussion. But it's been almost 4 years, and actually this research project was developed to include in the process, in the discussion of the process. In 2016, we also did one with other 9 drugs, and Marcelo was one of collaborated with us, and also to this process. So there are kind of information about it, but there is no decision. The Brazilian Federal Court of Accounts proposed to the Civil House of the President of the Republic to discuss to repeal of the sole paragraph of Article 40 of the intellectual property right. So there is a recent report from this court, and it indicates that the patent application is already protected by the provisions of Article 44 of the intellectual property law, which offers retroactivity to the patent application's claim. The TRIPS agreement does not provide such exception, and there is no such rule in other countries, at least no one in the intellectual property law. So there are some reports and documents to subside the decision, but it's still an ongoing process. I don't know if maybe Alan, who was supposed to be watching here and wants to take part and give more information. He's a lawyer and is following the discussion more. But the federal government is not taking any part on it today.
Okay. No, thank you very much for that update. I think certainly these are long processes, and it's quite striking to see in both contexts. For 4 years now, we've been trying to better understand, assess, come to some decisions, through the judicial system and through the legislative system on these policies. But I do wonder. I want to turn back to Ellen and then to you, Julia, for some closing comments. But I think that in the context of COVID, we are seeing a recalibration, let's say, of attitudes, possibly. I mean, I'd like to hear your, what are your perceptions? Are governments thinking differently about incentives for innovation? Is there a temptation to rely on the same old tools, which is, extension of monopolies, or is there really appetite for thinking about alternatives that might achieve the same or even better results vis-a-vis innovation, but without having to accept these very, very high prices that are often the result of the extended monopolies? What's your, how do you read the current mood on the part of governments in light of the major access questions that are coming up around, and innovation questions that are coming up around COVID? So let me turn to you, Ellen, and then to Julia before we wrap up.
Well, first of all, no one said at the onset of the COVID-19 outbreak, and when it became clear how serious this was going to be, no one said, "Oh well, that's fine. We have this generous incentive mechanism. We're just going to sit back and wait for the patent system to deliver the products that we needed." The exact opposite happened. Governments very quickly came together and brought together vast amounts of money to finance the research and development into vaccines, therapeutics, and diagnostics. So that I think was very telling. The industry was very quick in saying, we need more money, we need more money. The vaccine industry, which made 58 billion last year, their first response in February was, yeah, we'll work on vaccine, but you need to give us money. So in a way, this system of financing the research and development directly almost happens spontaneously. Now, what needs to happen on the other side, and we're not there yet, is that you need to attach conditions to that financing to say, if we front load this, then there is no need for these monopolies and exclusive rights. You have to then also share that knowledge that you generate with that public financing. That knowledge, IP, needs to be publicly available for others to use. The WHO has understood that, UNITAID has understood that, the Medicines Patent Pool has understood that. It's very encouraging that the World Health Organization moved quickly by establishing the COVID-19 Technology Access Pool, but we need now the government, and that was supported by governments, high income and low income governments, about 40 from day one. We need more to do so, but most importantly, those that are putting the billions in need to put the conditions on the spending of that money to make sure that knowledge is shared through the COVID-19 pool. I think that is a crucial next step. What I do see happening a bit, and that is, I think, concerning that governments you hear people say, well, we can't put too many demands on the pharmaceutical industry because we don't want them to walk away from this. I don't really understand that, because no one is going to walk away from 10 billion. So I think our government should show a bit more guts. Over.
Thank you. Julia, over to you. After so many years of seeing this kind of rubber band effect, longer and longer monopolies, how has COVID changed, if at all, the thinking regarding incentives for innovation?
Well, the situation in Brazil is quite different from what Ellen said about other countries. Our federal government is actually not acting very properly in the defense of the society and the population of COVID. So we did not make any investments or actions to make it better or to develop the innovations on this direction. One thing that was made, the first health minister of health that we had during the COVID, because we are in the third one, actually asked for the fast track of the patent evaluation analysis of 4 drugs that were with potential responses to COVID. So this was actually the only action related to patents. After side that, the president ordered the public laboratory of pharma laboratory to produce chloroquine in a very high amount of chloroquine and in very high prices. So actually was the only action that he made related to the drugs and pharma response. The national pharmaceutical companies are actually carrying out some clinical trials, and the National Congress is, there are a project to the intellectual property law to make the commissary license for health emergencies automatic. So it's actually on the Congress, in the legislative, that we have a movement to try to find solutions to work when we have the response, the drug or the vaccine to solve the COVID pandemic, and then so we can have these easier, I would say, access, or at least would be able to access it. But there is still, it's not on voting yet. There is the project, but it's not on vote. So what happens here, we have a very high technology dependence. Our trade balance has a huge deficit of about $5 billion in pharmaceuticals and pharmacochemicals. So we're actually quite worried about how we will be able to access these drugs and vaccines when it becomes available.
Mm. Thank you for that update. I think it's certainly too early to draw conclusions on what impact the pandemic will have on the way people are thinking about incentives for innovation and access, but certainly the acute concerns and the needs for access and I think the shortcomings of previous policies that have been put in place are definitely very, very relevant for us all to be aware of as we engage in ongoing discussions about policy change. Let me pause here and first thank our two esteemed speakers. Thank you so much for your excellent presentations and responses to the questions. I want to thank our very engaged audience from around the world for all of the excellent comments and questions in the chat. I misspoke earlier. I said we're trying to go for two-way flows of knowledge, but actually what the chat function allows for is a multi-way exchange of knowledge, and please do feel free to respond to others' comments in these webinars. The questions that we couldn't get to, we will send to our speakers in hopes that they might be able to respond to at least some of them. And last but not least, let me thank my co-organizers and colleagues, Marcela Vieira, who is a patent expert on Brazil and on access to medicines policies in her own right, on a broad range of issues. Thanks very much, Marcela, for all your hard work, and also to Sachio Yagi and Nora Sada, whose hard work has helped us to make this webinar possible on behalf of the Global Health Center. So without further ado, let me wrap up this webinar. We will be taking a break for the summer. We'll be back in September. If you signed up for our mailing list, you'll get an announcement regarding our next webinar. As soon as you close, you will get a link asking you to fill out an evaluation. And for those of you who want to watch this webinar again, it will be available in just a few days. So thank you again to Dr. Elena Thun, Dr. Julia Paraños, and to everybody. Stay safe and stay healthy.
Thank you.